And now it's time for our keynote speaker, Tony Allen. Tony is probably the UK's best-known mediator, specialising in clinical negligence. A practising solicitor for over 30 years before joining the Centre for Effective Dispute Resolution in 2000 as a full-time director and mediator. And today he's going to talk to us about the often challenging relationship between mediation and the law. Tony.
Thank you very much, Ness, for that introduction. I was wondering why I'd been asked to come, and it's nice to find out. It's really exciting to hear and be learning since we arrived about the clinic, and congratulations for what is going on and what is going to go on in the future. But my questions for you this morning are, is mediation, and are we mediators, in the right place? What remains to be done to put us where we ought to be? And what can individual mediators and mediation providers, whether they be a clinic or an organisation like CEDA, do to get the positioning of mediation within civil justice properly organised? Do we really work in the shadow of the law, or do we belong, or should we aspire to moving into the sunlight? And how can a keynote speech like this hope to help? And that's a question for me. I'm looking forward to the free flow of question and answers at the end of my session, or towards the end of my session, as I dislike reading speeches, but it was the only way I could think of to make sure I covered what I wanted to cover. I was incredibly lucky to get involved in mediation when I did. After about 30 years in private practice as a solicitor, towards the end of which I saw the introduction of our newly minted civil procedure rules into our firm, cold towels tightly bound around our heads, I collided with mediation. And after working through a 5-year overlap in my firm and working with CEDA and beginning to do some training and so on, I embarked on my second full-time career as a director at CEDA. And I've been working on that second career for about 22 years now, freelance now, mediating, as you've heard, particularly clinical negligence claims, and having been involved in training mediators all around the world. And although many mediations spring to mind, the people involved, the way the process helped them, the satisfactions and the frustrations of that work, I was lucky enough to get involved when I first arrived at CEDA in doing the next edition of the standard textbook that CEDA was producing, the ADR Practice Guide. And there was a rather a modest section about the law, sandwiched between what is mediation and how do you do it. And there was about 60 pages there. There was certainly no list of cases at the beginning of the book. And this generated my interest, and this ultimately ended up with my producing my own book, second edition of which, 300 and something pages with about 200 cases referenced in a table at the front of the book. 3 memorable events in which I became involved stand out in relation to the development of the law and mediation within it. First was a talk that Carl Mackey and I did to 28 Court of Appeal judges in 2002. Where people were still feeling their way as to how a court might sanction someone for not for doing litigation properly. And we were bold enough to suggest to these 28 judges that one day it might well be appropriate to sanction a party, even a successful party, for refusing to mediate unreasonably. And in the front row of these 28 judges, there was a tall judge, elderly, very bushy eyebrows, eyes closed, 2 hearing aids. And I thought, well, there's a lost cause, privately. 11 days later, Sir Henry Brooke, for it was he, presided over the case of Dunnet and Railtrap, in which, for the first time, a senior court said, we are going to exercise a power to penalise a recalcitrant claimant or recalcitrant party, even if they succeeded, if they unreasonably refused to mediate. And that was an absolute landmark case, and has remained so, and remains good law, though there are some judges who would rather it didn't. The second event that I got involved with was writing CEDA's submission to the Court of Appeal in the famous case of Halsey and Milton Keynes NHS Trust in 2005. Sitting in on the hearing and ever since writing more words about that particular case and that decision than any other case in relation to mediation. It's famous for purporting, and I underline the word purporting, to establish that for an English court to order ADR breaches Article 6 of the European Convention on Human Rights. This is now broadly regarded as wrong. The decision was all the more startling, though, because, as we discovered later on, counsel for the Law Society, who introduced the idea to the Court of Appeal, had been told by the Law Society not to take the point, but he decided he would take it after all. Thirdly, and more relevantly in relation to Scotland, Professor Hazel Gen's Hamlin Lectures in 2008, Judging Civil Justice. In particular, the one that she delivered in Edinburgh University in December 2008, entitled ADR and Civil Justice, What's Justice Got to Do with It? There's a fourth series that I'll come back to of events at the end, but of recent history, but I want to concentrate a little bit on Hazel Gen's speech there. And while Halsey will come up again later on, and I wasn't there when Hazel Gen delivered this speech. Charlie was there, and he can tell you how he felt about sitting there listening to it. The only part I played in that was to be invited to speak to her symposium at University College London, which she set up after her Hamlins had been produced. Now, I realise I've really following in her footsteps in the sense of probably rather dubiously, an English person coming up here and telling Scotland what to do. I do apologise for that. I don't think she did. In fact, I have a slight suspicion that she thought it might be safer to say what she had to say about ADR and justice in Scotland than in England. And the impression I have, perhaps particularly from Charlie, is that there were certain people up here, certain groups up here, who rather welcomed her approach and have indeed relied upon it in many ways since that time. But they do represent, I think, looking back on it 14 years later, the most articulate challenge to mediation as to what it is and what it isn't and what it should be. And it still requires proper reflection and the best answers we can give to the challenges that she gave. And I think those are the answers that I suggested we needed to answer at the very beginning of what I said. I think she was absolutely wrong about certain things, but we do need to be able to say why, even if we disagree with what she said, and to make quite sure that what we assert about mediation is resilient and meets the needs of our society and fits within the framework of the law. And her views have remained influential, I think, with the judiciary, both in Scotland and in England and Wales. For instance, in his first report on cost reform in 2011, Lord Justice Jackson in England described ADR, wrongly in my view, as by definition the antithesis of the administration of justice by the courts. And he accepted Hazel Gen's criticism of a culture which, quote, wishes to drive all litigants away from the courts and into mediation, regardless of their wishes and regardless of the circumstances of individual cases. It's amazing how judges quite often used to set up, and indeed some academics, dare one say, would set up Aunt Sally's, which one felt was entirely unfair, but and mischaracterizations because perhaps they didn't know any better. However, Lord Justice Jackson did undergo a Damascene conversion, because by the time he produced his final report on costs, he devoted the whole chapter to ADR, and he recognized it as efficacious in many kinds of dispute, including personal injury and clinical negligence, as a means of settlement and cost saving. And while not supporting compulsion for its use, he regarded mediation as underappreciated and underused, and that's a phrase that he's come up with several times since then. And now he recommended the handbook should be published, and that's now been published and is available. And as relatively recently as 2017, in a judgment in a case called Thakkar Patel, he said, the message which the court sends out in this case is that in a case where bilateral negotiations fail, but mediation is obviously appropriate, it behoves both parties to get on with it. If one party frustrates the process by delaying and dragging its feet for no good reason, that will merit a cost sanction. So, Hazel Gen has had an important voice, is an important voice, and not to be ignored.
The tenor of her views about mediation, as expressed in that 2008 lecture, was these. Mediation is a sound and useful process, so long as it doesn't undermine the value and the values of civil justice. She notes that it's capable of achieving creative solutions that would not be available to a court adjudication. That it focuses on commercial realities of disputes rather than legal technicalities, and it can repair damaged relationships, reduce conflict, and it's less stressful for parties than court procedures. All absolutely right. However, she went on to say that mediation is often promulgated as anti-adjudicative and positively socially useful as such, by implication, challenging the constitutionally vital role of mainstream civil justice, giving governments the excuse to reduce civil justice funding. And she talks, slightly luridly, I think, in her first lecture about an internal threat to civil justice emanating from sections of the judiciary and the emerging ADR profession in search of a market for their services. She continues, in the process of seeking necessary and laudable improvements to the administration of civil justice, voluble reformers have attacked its principles and purpose in a postmodernist rhetoric, which undermines the value of legal determination, suggests that adjudication is always unpleasant and unnecessary, and finally promotes the conviction that there are no rights that cannot be compromised and that every conflict represents merely a clash of morally equivalent interests. In her Edinburgh lecture, that was in her first lecture, which she was brave enough to deliver in London, she said that mediation is private, non-precedental, and may foment power imbalance. It's not adequately accountable, and does not afford better access to justice. Then, in a burst of what might be styled a shiny example of pre-modernist rhetoric, she declaimed this: are mediators concerned about substantive justice? Absolutely not. That is the wrong question to ask. Mediation is about searching for a solution to a problem. There's no reference to the hypothesized outcome at trial. There is no reference to the hypothesized outcome at trial. The mediator's role is to assist the parties in reaching a settlement of their dispute. The mediator does not make a judgment about the quality of the settlement. Success in mediation is a settlement the parties can live with. And here we go. The outcome of mediation is not about just settlement, it is just about settlement. Do we recognize this characterization of mediation from our various experiences, even if it was an exaggeration to make a point? Are we mediators never concerned about substantive justice? Do we mediators, a subtly different question, only search for solutions to problems? Is there never reference to the hypothesized outcome at a trial during a mediation? Is it ever our job within a mediation, quote, to make a judgment about the quality of the settlement? Is it wrong for resolutions to be chosen because the parties can live with those terms rather than the terms being somehow objectively right and wrong in the circumstances? And what do you think about her much repeated aphorism? The outcome of mediation is not about just settlement, it's just about settlement. Before seeking to answer these questions, just a couple more quotations from her to clarify and buttress her views and a summary of her conclusions. She said, these processes are called alternative because they are ways of resolving disputes that theoretically do not require the involvement of any aspect of the legal system, theoretically. And because the approach to achieving settlement will not depend on reference to legal rights or the legal merits of the dispute, will approach the dispute as a problem capable of solution. The eventual settlement can incorporate anything to which the parties will agree and does not have to bear any relationship either to the type or to the magnitude of any remedy that would have been available under the law. To be fair, she actually commended that aspect of mediation in another point. Indeed, the spirit of mediation is precisely to shift away from a focus on legal entitlement to a problem-solving framework of reference. It's about different interests and seeking to achieve a settlement that maximizes the opportunities for both sides to achieve their interests. And later, she said, in civil justice, at least, there is an interdependency between the courts as publicizers of rules backed by coercive power and the practice of ADR and settlement more generally. Without the background threat of coercion, disputing parties cannot be brought to the negotiating table. Mediation without the credible threat of judicial determination is the sound of one hand clapping. Really good rhetoric, actually. A well-functioning civil justice system should offer a choice of dispute resolution methods. We need modern, efficient civil courts with appropriate procedures that offer affordable processes to those who choose judicial determination. And of course, we would say there needs to be the offer of mediation on the way, because that also provides what people need, I suspect. Her conclusion as it relates to whether courts should mandate mediation is that it should not be mandated by courts. And on this, she says that Halsey was right to limit mediation development, and she expressed surprise that a number of judges were advocating growth in the use of mediation. At the Halsey decision, she says, it attempted to turn back the tide, the decision having been given by a judicial ADR non-believer, or at least a judicial ADR skeptic. This created a little bit of embarrassment because Lord Dyson, who has delivered the unanimous judgment in Halsey, felt the need to deny this description of him in a speech he gave in 2010 when he admitted that Halsey might not be entirely right. He said, one of the more colourful accusations levelled against me was that I am an ADR non-believer, or at least an ADR skeptic. That is Professor Hazel Gane. I'm quite happy to admit that I'm not evangelical about mediation. I didn't think and still don't think that it's necessarily appropriate for every dispute. But I don't consider that either of these epithets used by Hazel Gane accurately reflects my views about mediation. Far from indulging in ADR atheism, I, in fact, am a strong believer in its merits, although I don't think it necessarily appropriate for every dispute. Rather presciently, actually, in her report, Twisting Arms, Hazel Gane thought that Halsey got this bit wrong. She actually said it's really arguable as to whether a direction to attempt mediation prior to a hearing would infringe Article 6. It's a procedural step along the way to a court hearing if the court doesn't settle, doesn't exclude access to the courts. Absolutely right. It's not a view, though, she chose to highlight when she was delivering her Hamlin lectures. And she said a lot positively about mediation. She has done a lot of research on the Central London County Court and various other schemes, and certainly reported a good deal of positive reaction by those who've been at it. They didn't want to be pressured to settle, but the benefits of mediation, she said, are often explained by medias against the likely experience of anticipated trial. Well, I'm not so sure that we necessarily do that so much nowadays. So it seemed to me that four main themes emerged from what Hazel's points were, and these are these. And I'll come to each of them in turn. Firstly, where does justice reside in the mediation process? Justice in inverted commas. Secondly, does mediation deliver fairness of process? Does it deal properly with things, for instance, like power imbalance? Thirdly, what is the proper relationship between the civil courts and the provision of mediation? Should the courts positively recognize mediation and even order its use as a proper part of modern dispute resolution provision? To what extent should mediators be accountable to the civil justice system? Or are they to be afforded special privileges? And does the growth of mediation help or do damage to civil justice? And the fourth point, does the greater informality and privacy of the mediation process demand higher and more transparent ethical standards of we mediators? So these are the questions that I thought were worth addressing, and perhaps I'll have a look at each of these in turn, and then we'll have a good debate about them. So where does justice reside in mediation? And of course, her famous remark, the outcome of mediation is not about just settlement, it's just about settlement, is the key to the question that she is asking us. And this really jars painfully with my own experience as a mediator, especially if it's coupled with that comment, which I read twice, there is no reference to the hypothesized outcome at trial. My mediations, and they are now mostly claims between patients and hospitals, are always conducted with reference to the hypothesized outcome in trial. In a clinical claim, there may be a deep dispute about whether there has been a breach of duty or whether any breach of duty has actually caused additional damage over and above what the claimant would have suffered anyway. And there may be disputes over a number of different heads of damage. And the parties usually arrive at a mediation a long way apart on such issues. And sometimes the provisional monetary gulf is enormous, sadly amounting to millions of pounds sometimes. So what discussions take place during the mediation? How can they be rendered safe, free from any fear that sending a signal of possible weakness might be used in the signal? That's meant by conducting the mediation in this privileged atmosphere, with the agreement as to confidentiality of such discussions, so the parties get to trust the fact that they can't damage their on-the-record case or have any provisional, if unfulfilled, willingness to compromise reported to the trial judge. And furthermore, they can't be criticised by the judge for not settling. This is the confidential world which we create, the bubble that we create for people to have discussions in. And having established this, and of course, they can trust the mediator too, so that when the mediator is in private within one room or another, they can open up and they can try things out and not feel that they're actually damaging their own case in doing so. And having established these various components of the safety of the process, they can have honest exchanges direct all through this trusted mediator to confront their own opponent with their own strengths and their opponent's perceived weaknesses, so as to inform a reappraisal of the risks of not achieving their own best case at trial. And having done that, a bidding process which turns their thinking into monetary terms and indeed non-monetary outcomes as well, takes place to see whether an acceptable risk-discounted resolution can emerge. Tested always, it seems to me, against the prospects of success or failure on the point in question if the case goes to trial. The illustration I often use is assume a claim which is worth £100,000. Forget costs for the moment. All a judge can do is to award £0 or £100,000. How do you begin to settle a case like that? And you might say, how often will you have discussions and they say, okay, we'll pay you £100,000? Not very often, because there's usually litigation risk that people are prepared to acknowledge and take a little slice off the best value of the case to allow for that and to allow for any failure of a witness to get there or an expert witness to not come up with truth and so on. Do they ever settle for £0? Very occasionally in my mediations, they settle for £0. The defendants come and they persuade the claimant they've got no case, and they pack up their bags and they go away with nothing. Do they get together and say, well, look, we've got this £100,000 case. I tell you what, let's split the difference now and agree 50K? The answer is no. People don't do it like that. They are determined usually to confront their strengths and try to make light of their weaknesses. And so a mediation takes place. And let's say it settles for £70,000. Not an untypical kind of outcome. What the subplot to that settlement is this, that the claimant is saying, well, what a pity I didn't get £100,000, but I got £70,000 because actually 3 times out of 10, I was going to get nothing. And similarly, the defendants will say, pity I had to pay £70,000, but 7 times out of 10, I was going to have to pay the lot. And that unspoken risk assessment goes on, as it were, under the surface and is wrapped up in bids and so on, is, it seems to me, reflective of an appraisal of what an outcome might be at court. And it is tested against what an outcome might be at court in the course of that kind of debate. And so, at my mediations, I find people are constantly saying, well, you won't win about that point at court. And in private, usually not even with me there, they may well say, I think that's a bit of a risk, pushing that one too far. Let's see if we can find some kind of better outcome. What the late Sir Cameron Lightman called an approximation to justice. But I don't think it's so far away from justice as to be in any way offensive or inappropriate. And of course, it is possible to have mediations in cases where the law is not clear. I mean, one hears the explanation for, oh no, you can't mediate this because we need a precedent. Well, that's fine, so long as if you get the precedent going against you, it isn't too painful. And indeed, there have been many mediations where the law has not been clear. Perhaps the most shining example of that, which I was involved with, was the retained organs litigation, where hospitals around the country, particularly in Liverpool, had, without any parental permission, retained organs of dead children, not negligently killed children, children who died, that the consultant pathologist said, we might keep their organs for research purposes, and they were mouldering in a huge sub-mortuary for years and years and years, and the parents didn't know, and it bubbled up. out of the Bristol Heart inquiry that this had happened, and outrage burst forth. But what the law was in relation to the retention of those organs was completely unclear. And so there was a mediation set up between the litigation groups and the hospitals involved, and certainly as far as Liverpool was concerned, hugely successful, where without going to court, every family received a fixed sum of money. I think it's £5,000 per child. There was a commitment to law reform. There was a commitment to an apology. There was a commitment to well, those are the main things that the court could not have ordered. A memorial outside Alder Hey Hospital. Contrast that with what happened to the national group. They couldn't agree, they didn't get what they wanted, they went to court. 50% of the people who got money in Liverpool were told they were not entitled to any damages at all. And the other 50%, no one quite knew whether they won or lost. And we had to have yet a further mediation and horrendously complicated negotiations to find out who got anything what. And I rather fear, I never found out, I rather fear the whole of the compensation paid was swallowed up in legal costs. The families got very, very little. So the other point about settlement is, I would add the words or not to that. Success in mediation is not necessarily about settlement. There are some cases that don't and shouldn't settle. It's almost got to the stage, actually, where I now take a certain amount of pride in the fact that not all, perhaps as many as sufficient, not all of my cases do settle. Because if actually we mediators were strong-arming people into settling cases against their will, there would be plenty of justified criticism of us for diverting cases away from the civil justice system and strong-arming people into deals. Some of these cases are very difficult to settle. I have been involved in some of these cases involving decisions over the best interests of children, whether treatment should be terminated or not, where a hospital feels there's nothing more they can do for them. These are incredibly unlikely to settle. But the judges in the Court of Protection, the Family Division in England, have said more than once, we think it's a good idea that you do have a settlement in these cases, even though it's very difficult for people to emerge with agreements. And I think the unspoken opinion about that by the judiciary is, thank goodness we can be sure that there's been a thorough, safe, honest, protected discussion between the parties, which sadly has not led to agreement. But we can believe now that no stone has been left unturned about whether this child should live or die. And now we'll roll up our sleeves and make that decision accordingly. And there's certainly some cases of that kind have led to settlements and mediations. And even though it's rare. Okay. I go back to supporting Hazel when she says that the courts can't order everything that mediations can deliver. Indeed, there are some mediations which don't even need to get to the point of talking about money. I had one case of a child who had been negligently damaged at birth and hypoxic, but sadly had died aged 2. And the financial side of that was perfectly easy to get settled by agreement. What was less easy was to answer the parents' questions about what had gone wrong, why that had happened, what changes had taken place. And we had a day-long mediation where this was the topic. And senior clinical staff were present to explain what had happened, to empathize for the parents, to have a voice. So often what we do as mediators is give people a voice and let them believe that someone who should have heard what's going on has heard it and taken it seriously. And of course, there are cases, and maybe this will be true in mediation clinics here, where in a sense, what's happened is that the relationship is broken down, but the dispute has been shoehorned into a kind of legal dispute to try and sort of make sense of it. That's the kind of case where mediation really comes into its own, it seems to me. What we really are able to do is to offer a process in which people can sort out their fractured relationships and map out a future relationship the courts are really not terribly interested when they're deciding about who was wrong and who was right in the past with the future. So let me move on to fairness of process. Do we as mediators offer a fair process, and does it deal properly with matters of power imbalance? I think it must be axiomatic that we try heaven's hardest to deliver a fair process, free so far as human frailty can manage, to escape bias, to give people the opportunity to speak to each other and listen to each other. And there have been people who have said, well, mediation doesn't really protect people from power imbalance. Oddly, I find in my kinds of cases, power imbalance is absolutely inherent. I mean, you will have got a patient who's taking on the NHS, or even if they perceive it as a patient taking on the local hospital trust. It's an enormous organization with thousands of people in it, and they will feel very often disempowered, underempowered, and luckily, for me at least, they are, in my case, it's pretty always represented. So they have got someone to help them formulate their case. But particularly where parties are unrepresented, there can be a sense of power imbalance even in smaller cases. I take comfort in the cases that I run from the fact that when we get into the mediation room, assuming we do, 3 or 4 fairly normal looking people are sitting on either side of a fairly normal looking table. And suddenly the problem, I believe, for claimants who've been grappling with this faceless monster are actually engaged in a conversation with people who say they're interested to listen, show that they're prepared to listen and be responsive. And indeed, the Goliaths of this world, the big institutions who turn up at mediations, have got lessons to learn about how they speak and how they prepare and how they allow for the fact, and we have a role in coaching them to do that. Of course, I said something about the value of letting people have their say. Frankly, anyone who says in England, I'm really looking forward to having my day in court, has been under-advised. A day in court in England now, at least in theory, and I think I've learned in reasonable frequent practice, will involve, of course, maybe a traditional courtroom where the only person who's facing the parties is the judge. Everyone else is looking away from the parties, including your own advocate. And you're sitting at the back of the court with several rows between you and your advocate, waiting for your magic moment to go into the witness box and tell your story. And you've been advised by your counsel that there are 4 questions that you will be asked by your counsel at the beginning of giving evidence. And you've been told what the answers are. Well, you probably know the answer to the first one, which is what is your name? And the second one, your address. If you're not to know, you manage that one. The third question, you've been told the answer to this is yes. Are the contents of your written statement true? And the fourth question, and you've been told the answer to this question is no, is there anything you want to add to your witness statement? If you want to add something to your witness statement, the judge will cock an eyebrow and say, why wasn't this in the witness statement in the first place? And you now sort of embroidering and so on. And questions 5 to 105 are cross-examination. We can't pretend that English trials give people the chance to have their say and to give them the kind of day in court that they might actually value. And a mediation does, seems to me. One of the most important things I believe in delivering to parties of the mediation is the opportunity to have their say, talk to people who ought to be listening to what they have to say, no rules of evidence, no cross-examination. And the number of times I have seen burdens fall off people's shoulders because they've had that opportunity and have been able to at last say what really hit them. And the number of times I've seen hospital representatives visibly shaken by the impact of what they've heard on them, and really seeing for the first time through the eyes of someone who has been a customer of theirs how badly it's affected them. It's very moving, and quite often one of the monetary outcomes one gets in clinical claims is a commitment to invite someone to come in and talk about the patient experience to staff at the hospital, and people often take up that offer and are very keen to be doing so. However, I'm not going to overplay the word transformative when it comes to mediation. I think Hazel again did have something of a point when she was talking about postmodernist rhetoric, which I think is essentially expressed in an American accent. I mean, I don't feel that there has been a great deal of transformative enthusiasm about mediation in this country. A bit, but nothing like as much as some of the academics writing about mediation in the States. And Charlie, when he had heard Hazel again, wrote a very interesting article and warned us that we must be careful about the rhetoric we use over here, saying, I make the following assertion: mediation rhetoric is often out of step with mediation practice. Indifference to norms like justice and fairness may still feature in mediation rhetoric, but I believe it ignores the facts on the ground of daily practice. And he said, to return to Professor Ginn, she is in a way doing mediators a favour. By presenting us in our most feeble light, she shocks us into rethinking what we say about ourselves. If we can bring our rhetoric more closely in line with practice, this must be more honourable and better for our clients. Okay, I'm going to say a little bit now, fairly quickly, about the other 2 points. The proper relationship between the civil courts and mediation provision. Should the courts positively recognise mediation and even order its use as a proper part of modern dispute resolution provision? More so than we had ever thought before is my answer, although I still approach the idea of call it mandatory, call it compulsory. The language that is being used in England and Wales now is integrated mediation and automatic referral. So talking about it as being something that will slide without any great fanfare of trumpets into the civil justice system. And we do have, it seems to me, the obligation to satisfy some of the doubts and queries of the judiciary about our practices. We have to make it as clear as we can the ethicality about of what we do. We do claim a degree of privacy to what we do, and I suspect judges are slightly suspicious of that. I'm going to talk a little bit more about that in a little while. But now in England, certainly, we do have a very firm commitment that, particularly for small claims, mediation is beginning to become automatic. Service, not by mediation clinics so much in England and Wales as by the Small Claims Mediation Service, which was established back 2003, I think. I could see to train one or two of the very first mediators in it. It now self-generates. And they're talking about expanding this service by 700%, so that it is available for every small claim in every branch of the county court throughout England and Wales. And that professional reform has come from the Ministry of Justice. I think ministries of justice are never entirely beloved by the judiciary, and one of the problems there is getting the right balance of support between the government and judges. And it's really important, and what heartens me so much here about your mediation clinics is the support that sheriffs are giving to them from a local level, which is where small claims frankly live. And it's very exciting to hear what you're doing about that. And I think we may even manage to find the abolition of the acronym ADR. Everyone is acknowledging, I think, now that alternative is no longer a useful adjective to apply, particularly in clinical evidence, for instance. Less than 1% of issued cases reach trial. 15,000 new claims a year, something like 150 trials in cases. So settlement is the norm, the huge norm. And mediation is increasingly contributing to that. I think there's a price to pay as well, in that we have to be accountable to the civil justice system. I don't think we can simply say, mind your own business when it comes to the courts. without prejudice privilege certainly does apply automatically. Quite what's happening about confidentiality is still a mystery to me, at least. There are various slightly conflicting first instance decisions about whether a mediator can enforce the corporate confidentiality of the proceedings in a way that the mediator cannot enforce without prejudice privilege. And there hasn't been any Court of Appeal decision about that. And on the whole, the judges are held, even in Halsey, they would say we don't want to know what goes on behind the veil of mediation. But if misfeasance goes on behind the veil, I don't think that we can expect what goes on in mediation to remain entirely private. What I hope we can do is to resist being called as witnesses ourselves. It seems to me that I'm hoping that there's very little that we could add to the considerations of the judge if it came to what went on with the mediation. Was there duress? Was there misrepresentation and so on? I, for one, hope that there are only two things that land me up in prison. One is running over a cyclist that I didn't see, and the other one is contempt of court for refusing to give evidence about what happened at the mediation. So if either of those happen, please come visit. But I think our instinct as mediators should be not to acquiesce if we are asked to give evidence about what happened at the mediation. You'll have to decide whether you're prepared to go all the way into Barlini jail, but if at least raise the argument, say, is this really necessary? Because I believe that some of the cases where mediators, and there are very few, about 3 or 4 cases in England where a mediator has apparently given evidence. And I think they mostly did so by consent, maybe by perhaps a misguided view that they were in somehow offices of the court. And I suspect they were all legal and easily qualified mediators, so with their lawyer hat on they were, but I don't think they were as mediators. So these are the confidential areas. And then finally, the last 2 points. The one about does the growth of mediation enhance or do damage to civil justice? I've always thought that mediation was entirely the wrong target for this, from those who worried about the starving the civil courts of precedent. The right target for that is arbitration. Arbitration takes cases away from the civil justice system. In theory, an arbitrator could decide and receive a fee for deciding the same thing 6 times without feeling bound by anything that anyone ever said before. In theory, I suspect it's a little bit more fun than that in the end. But there really doesn't seem to me to be, certainly in England and Wales, any shortage of precedent. This may be different in Scotland. And you're a much smaller jurisdiction. You are your own legal system here, and judges might be concerned about the starvation of precedent. But I don't get the impression that judges are actually underworked. And I've never noticed a shortage of precedent. You go on Bailey, the British and Irish Law Institute, there seems to be case after case after case on every conceivable point. And to criticize mediation for this on the basis that it's an obstruction to trial, I hope is about to be known. There is the possibility of a hearing in the Court of Appeal later on this year of a case, believe it or not, about Japanese knotweed, just about as relevant to mediation, or mediation is just about as relevant to that case as mediation was to Mrs. Halsey, which may give the Court of Appeal an opportunity to rule on whether Halsey is right in its Article 6 approach. The name of the case is Churchill and Merthyr Tydfil Council. So finally, the question of ethics. We spend a lot of our time doing things which no one else but ourselves see in terms of the way we do it, apart from the parties we're working with. But even then, we're doing things with one party and the other party isn't there. The kind of standard I try to teach myself and apply to others is if in a private meeting with one room, the other party had been there watching you, leave aside what the actual private content, would they have approved of the way it was done? You were operating neutrally, you were operating fairly, you were operating you weren't colluding with them. These are the kinds of things that we had to restrain ourselves from offending. And I think that it's something that the collegiality of things like a mediation clinic starting, a mediation provider like CEDA can make provision for people to get together and to share and to moderate their experiences, and to the codes of conduct that we signed up to are really quite general in many ways. We are supposed to be neutral, where we are supposed to be without bias. Where can we avoid it? Where can we avoid making mistakes about that? And the opportunity, I think, for us to do that with each other is absolutely invaluable. So I talked just finally about a fourth significant event. Last Monday, there was a conference in London at which the Ministry of Justice told us that they were going to introduce this across the country small claims system, saying that our objective is transforming a system predicated on adversarial conduct to one that promotes dialogue and compromise. That is what the government's policy, emanating from the Ministry of Justice, is going to be. Added to which, a senior Court of Appeal judge attended, and talking about mediation forming an inseparable part of the civil justice system, a memorable phrase, sewn into its fabric. She talked about shadow of, shadow of the law. She talked about the long shadow of trial as being something that puts quite a lot of people off. And it seems to me, in answer to my questions, we are getting there. We are getting there. We've got still a long way to go. And if I may just finally close by reading two little snippets from CEDA's 10th audit. Mediation has arrived at its desired destination within the mainstream of the litigation system, but its race is far from run. The move towards mandatory mediation appears to be the next challenge on the horizon, and this audit suggests that our profession is well placed to meet the need. And also this, our historic growth to a total of around 17,000 mediations a year is certainly an impressive achievement. That excludes small claims mediations, incidentally, and also mediations associated with the employment tribunal. But with some 247,000 contested civil law cases in England and Wales each year, the need and the opportunity is still vast. So with new approaches and new areas for implementation of mediation, we're still evolving, but the journey has not ended. And here we are together on another journey. You're on a slightly different journey here, but I think we're all making that journey hand in hand.
Well, I'm sure you'll agree that was a phenomenal, if breakneck, whiz through so many really fascinating questions. Tony, that was fantastic. Right, let's open up now to your questions and to questions from Zoom as well. I'm going to be straddling both Zoom. Are you going to have Zoom up on that laptop?
Getting it.
Right,
Just working on
so
it. That's fine.
if you are watching online, please do put any questions into the chat, and I will try my very best to straddle both arenas. For those in the room, first of all, while we get the computer side set up, who would like to kick off with a question? Gentleman there.
Hi, I'm Ben Waters from Country Cross. Thank you, Tony.
Nice to see you.
Great talk. You trained me many years.
I remember.
2006. There we are. You mentioned small claims mediation. The changes that the NLJ are thinking of introducing within the next 12 months, I guess, surely are going to be a bit of a game changer, aren't they, on a number of levels. You mentioned also that the increase in small claims mediation, this is claims of up to £10,000 in England and Wales, for those of you in Scotland. You mentioned that there will be a 70% increase.
700%.
Sorry, 700%. Wow. So,
Someone's got to write a very large check.
yeah, and 700% increase. I mean, that is colossal. Surely the small claims mediation service that is currently constituted is not going to be able to happen.
No, it's not.
So this is going to be a game changer maybe for the small claims mediation service providers or those dealing with small claims.
Ben, I'm going to try and summarise that for those online in case they couldn't hear. So Ben raised the question about the small claims mediation service, how can they logistically cope with this game changer of a 700% increase in mediation as instigated by the Ministry of Justice? Is that roughly?
Yes, that's roughly it. And I don't know the answer to that. I don't know how they propose to do it. I mean, but it seems to me that it's extremely unlikely that they will wave a magic wand and on the 1st of January 2024, there will suddenly be small claims mediators trained by the small claims mediation service themselves, all set to go for every branch of the county court around the country. Whether this will take the form of contracting it out, I mean, mediation clinics like you have at Canterbury may be a very useful service provider in that kind of situation. So I wouldn't rule out the possibility that there may be some chance for clinics in England and Wales to, as it were, take some of the burden off the small claims court if they meet certain standards, and I'm sure that would be perfectly possible to work it out. But I don't see that suddenly it's all going to be there. It's going to be a huge business of multiple times multiplying the number of mediators. Where will they get them from? I mean, my impression is that small claims mediators in England and Wales have mainly been promoted county court staff. Well, county courts in England staffing is pretty pathetic in terms of numbers and efficiency. And so if they suddenly take away all their best people to become mediators, one worries about what's going to happen to the court system too. So I'd be very surprised if it wasn't possible for there to be a degree of private enterprise down there as there is up here. So commendable.
Thank you. John Stark at the back.
Actually, that was as ever great. Thanks so much indeed. I've got a couple of questions about your point number 3, and that's the relationship between mediation and the civil justice system, the court system. You mentioned the question of whether or not courts should order mandatory mediation or mandatory mediation, and that notes the reframing, the use of the word integrated, automatic referral rather than compulsory and mandatory. The Scottish courts are presently undertaking a major rewrite of the whole Scottish court rules currently, and in the review of that, we're told that the use of procedure rules will not make ADR compulsory, no use of ADR still, and the use of procedure rules will not contain a rule provided for cost sanction for the use of ADR. So that's the context in which we will go forward, and that would be, I heard this from the Lord President himself yesterday, that's the context in which we go forward with the State Speaker. So I'm really interested in what advice you would give us in Scotland as we manage the situation in which we find ourselves, in which those words compulsory and sanctions will be. That's the particular question. I suppose the second question is this, though, is there any danger that we overemphasize the relationship between mediation and the civil courts, or we place too much reliance on that relationship in our quest to see mediation develop across? So that's a general second question.
Okay, so again, just for those watching online, John's question was, what advice does Tony have for Scotland going forward on our journey to balance the use of mediation in the civil justice system? Is that correct, John?
Yeah. I think my advice would be this. It's amazing what has been achieved simply by a lurking threat of sanction. I mean, it's taken England and Wales as long as it's been, from 1999 when the civil procedure rules were introduced, to now, even to contemplate integrating mediation into civil justice processes. What has been going on up to now has been the lurking threat of sanction, and rather which has operated, I think, to a degree, and in certain sectors, people have, like the commercial sector, like professional indemnity claims, and now more recently in clinical negligence claims, those who are actually engaged in doing them have seen the sense of creating it for its own value. I think in the commercial sector, it's because you can avoid unnecessary damage to commercial reputations. You can reconstruct your deal if that seems sensible. You can bring other things into other bits of business relationship into the pot in order to produce something. So there have been various pressures, and all the courts have really done it really has been said, just be careful. If you unreasonably refuse to mediate, you could be penalised, and the one thing that lawyers don't like being is penalised in costs. So I think that if you can't go the whole way towards mandatory or automatic referral to mediation yet, that may be something that you come back to down the road once everyone's got used to.
I'm going to go next, if you don't mind, to an online question. So this is, I haven't given me permission to use their name yet. I did ask the question, so I'm just going to ask it on their behalf. Isn't mediation a matter for the parties to decide whether it is about settling or go deeper into their relationship and sort out other issues and deal with the elephant in the room?
Yes, I mean, it's always for the party. I'm not quite sure which elephant we're talking about here. There are many, but it is always for the parties to sort out their outcomes, and it's, I believe, really for their advantage that they're given the opportunity of exploring whether there are ways they could sort that out which are different from what would happen if they went to court. But if they can participate in those discussions without any adverse consequence, they can't be criticised. They can't be criticised. It cannot be reported to the court that they ever showed a sign of compromise if they don't want it to be known. They can not be criticised for not settling. If they take advantage of that safe space in which to have those discussions, what is lost? I mean, except the possibility of the cost of it, and the cost of it is always going to be one of those things that has to be debated and funded.
Thank you very much. Now I think that the lady in front of you, you're asking a question first.
Yes, hi Tony,
Hi, Sue.
University of Exeter. I just want to thank you so much. That was a really interesting sway through the whole of mediation, which is fantastic to hear. I just wanted to ask a question, picking up on some of the things that you mentioned. We were talking about justice in mediation, growth of mediation, and mediation becoming part of the justice system. And I suppose my question is really around the point you made about rhetoric and mediation rhetoric. And I wonder if the growth of the rhetoric is because that's all we've got, in that when I ask my students that I'm teaching about mediation, nobody's ever been to a mediation or seen one. And it's great to have a clinic and you can experience it. But transparency in civil justice is really important these days in terms of that question around justice. If privacy is a really important principle, can that coexist against something which is going to be part of the civil justice system? Sorry.
Good question. And I think the fact that it is there will always be a grit in the oyster for the judiciary. I mean, I think that the fact that you can't, that bit of what goes on is not going to be aired to public view will be something that could cock an eyebrow. He said, mixing his metaphors wildly. On the other hand, so is without prejudice correspondence. I mean, a lot of what goes on in relation to civil claims is off the record. And I think we all would find it very easy and quick to agree that the value of mediation is that it does give people this safe place to have conversations which they might not otherwise feel they could have safely in order to explore an outcome. And if you can always go to court without adverse consequence, then I think there's no need for alarm. I think that would be my approach to that.
I'm going to very briefly wrap up with one final question. We've got a couple of minutes just left to answer it, so we might squeeze another one in. Victoria Harris has asked online, in the light of the anticipated change, what more should we be doing to raise the profile of mediation with the public?
Well, I think anyone who has actually got a friend who writes scripts for Coronation Street or EastEnders or any such thing should make quite sure that it happens there and in a realistic way, and not just about family disputes. I think we can never throw up the opportunity. We should never throw up the opportunity of trying to tell people about it. We do suffer, of course, from Sue's very point about the fact that it is a confidential process. This actually ties our hands in claiming our successes, frankly. And when I came to write my book about medical negligence mediations, clinical negligence mediations, I had to be very brave and think I just cannot get clearance from every single person about giving an outline anonymously of the facts of each case. And so I just had to do that without permission. And I think they're all concealed, and no one's ever written a moan about it. But you do feel constraints when you're talking about what happened at the mediation because it was confidential. And I think we just have to be brave enough to decide what the parameters are of what we can say about it, and give it illustrations to the world about how it can do things and how it doesn't actually adversely affect you, and hope for the best. But I think the more we say, the better.
Excellent. I do apologise for those of you who haven't had a chance to ask your questions, but I'm concerned it's now 11:15. Thank you so much, Tony. Please give Tony a round of applause.